Welcome to the Business Blog with lawyers from Boston law firm The Jacobs Law. The opinions and information discussed during this show are of a general informational purpose only and are not intended to be specific legal advice and should not be used to make specific legal decisions. You should always consult an attorney who knows and can advise you based on the facts and circumstances specific to you and your business. Prior cases and case law discussed are not an indicator of future results or outcomes. Your host for today's show, attorney Travis Jacobs, is a licensed attorney in Massachusetts and is the managing partner of the Jacobs Law. He has been working to help entrepreneurs and small businesses for almost a decade, and for the last 4 years has been selected by Super Lawyers magazine as a rising star in business litigation. And now, here's Travis Jacobs.
Okay, ladies and gentlemen, welcome back to the Business Blog with Boston law firm The Jacobs Law. I am Travis Jacobs, the managing partner of The Jacobs Law and host of today's show, The Business Blog. For all those business owners and entrepreneurs out there who don't already know, I want to tell you a little bit about The Jacobs Law. We are a business law firm. So what does that mean? It means that not only do we run our own business, but we represent business clients and entrepreneurs, and we help people who are looking to start a business or buy a business. We help people looking to sell a business. We almost exclusively represent small and mid-sized businesses and entrepreneurs at the Jacobs Law. And we also help people with contract disputes, drafting contracts like employment contracts, independent contractor agreements, non-compete agreements, partnership agreements, all sorts of contracts. We help people file trademarks, deal with ownership disputes, obtain licenses and permits like an alcohol liquor license, or even a municipal license like a used car dealership license. We handle all of these things, and a big part of our practice involves representing businesses that are involved in litigation. We represent businesses from both sides as plaintiff and defendant for things like breach of contract, ownership disputes, partnership disputes. And we do licensing and permits at the municipal level and the state level. So, for example, if you've received an order to show cause from the Division of Professional Licensure, that's something that the attorneys in our firm can assist you with. So before I start today's show, I want to get to a quick disclaimer. The hiring of a lawyer is an important decision that should not be based solely upon advertisements. This radio show is not intended to be an advertisement or a solicitation. The statements made in this radio show are of a general, informational nature only, and are not a substitute for individualized legal advice. You should always contact an attorney directly to discuss the facts and circumstances of your particular case and specific to your particular business or legal issue. No action should be taken in reliance on the statements or opinions made during this show, because every case is different. The description of court cases, decisions, awards that we go through in this radio show do not guarantee a similar outcome in current or future cases or in your particular case. Transmission of the information in this show is not intended to create, and its receipt does not constitute, an attorney-client relationship between the Jacobs Law, Travis Jacobs, and any listener. Okay, got the disclaimer out of the way, now let's get to today's show. I want to do a quick recap of last week's show because it pertains a lot to some of the issues we're going to talk about today. If you didn't catch last week's show, you can listen to it anytime by downloading the WBIX 1260 phone app from the Apple Store or the Google Play Store. And you can also find it on am1260thebuzz.com. It is a free app, and you can listen to all the Business Blog shows anytime you want. We're also getting a website together for the show, and the URL for that will be www.thebusinessblog.com, and that's business and then bLAWg.com. So if you're listening to the show when it airs on a Saturday from 12 to 1 p.m., or at least this Saturday from 12 to 1 p.m. The URL, the website won't be up yet. But if you're listening to this recording on the podcast in a week or two, then you'll be able to go to our website, download our show, and get some additional resources and information. So last week we discussed the classification of workers as either employees or independent contractors. Now this turned out to be a pretty hot topic for our listeners, so I just want to dive back into it a little bit and go through a couple of cases that I found interesting that sort of exemplify where the end of these rules, sort of where the rubber meets the road. We explained last week that Massachusetts has one of the strictest tests in the country for determining whether a worker is classified as an employee or an independent contractor. Under Massachusetts law, there is a presumption that all workers are employees for the purpose of paying wages and salaries. And the worker must meet every single element of a three-pronged test to be properly classified as an independent contractor. And that's one of the reasons why it's one of the strictest tests in the country, because the worker and the services they provide, their relationship to the employer or the party that pays them, has to meet every single element of all three of these three prongs. And the failure to meet any element or any one of the prongs results in the employee being classified, as far as the law is concerned, as an employee. So if you have a worker who you're classifying and compensating as an independent contractor, and you listen to last week's show and you realize that you may be misclassifying them, it's certainly something you should take a look at. You should call an attorney to discuss your specific circumstances to determine if you need to take corrective action, and also determine if you need to start compensating that worker as an employee going forward. Of course, there are exceptions to every rule, and we got into those a little bit in last week's show. But there are a couple of additional examples based on some cases that I wanted to just talk about quickly today. It might take me about 20 minutes, but I think they're really informative as far as these particular industries go. And so if you're an employer out there in the industry of a real estate broker or a trucking, transportation delivery company or a taxi cab company, these cases are really relevant to what you're doing. And they're also very unique, and they sort of represent the exception to the rule, which is why I wanted to bring them up. So first is the real estate agents. There was a recent case. The title of the case was Monell versus Boston Pads, LLC. Now, in this particular case, Monell, the plaintiff, and three other real estate agents filed a civil action against several real estate broker firms, alleging that the real estate brokers had violated the Massachusetts Independent Contractor statute by misclassifying them as independent contractors rather than employees. The real estate agents claimed that they had been treated as if they were employees by the real estate brokerage firm, but they were paid as independent contractors. And obviously, they received a 1099 every year instead of a W-2. They did not have withholding taxes taken out of their pay. They were essentially paid, either a flat amount or a commissions only on a commissions only basis. And as a result of that, and as a result of their claims that the brokerage firm was treating them as employees, they sought the hourly pay and benefits of an employee in their lawsuit. Now, if you recall the three prongs that we went through last week, and if you didn't listen to our show last week, I urge you to download the app and listen to the show on the podcast, because it is very informative on these three prongs. And I don't want to get into all of them again today, but there's three prongs, and they were in play significantly in this particular case. In particular, prong one, the control and direction played a big part in this case because the real estate agents had claimed that they were closely supervised by the managers, the employers, that they were subject to mandatory office shifts. They had to show up at the office at a very specific time, from a time in the morning to a time at night. They had to show up at the employer's workspace, at the employer's office. They weren't necessarily working in their own office or in a space that they leased or rented on their own. And they were also at times required to answer phones and to take out the trash. Also in play in this case were a series of statutes, and this was sort of the crux of the heart of the issue in this case. In this Monell case, was a series of statutes that set forth the licensing and registration provisions governing real estate brokers and real estate agents. Now, for you real estate brokers out there, I'm going to give you the statute. It was Mass General Laws, Chapter 112, Sections 87 pp through 87 DDD and a half. I don't number these. I'm not responsible for that. As well as General Laws, Chapter 112, Section 65A through 65E. Now, you can Google those statutes and you'll find them very easily, but I suspect that the language in them is going to be so dry and generally so complex that, if you're a non-lawyer, you're probably better off contacting an attorney to ask them, what do these statutes say and what are your compliance requirements? But in a nutshell, these particular statutes require a real estate agent to work under a real estate broker. In other words, a real estate agent can't just simply go out, get their real estate agent license, and just operate completely independently. They are required to work under the supervision of a real estate broker. And so when you hear a term like that, and you remember prong one from last week, under these statutes, these real estate agents are essentially required to work under some degree of direction and control by the real estate brokers. And the brokers are required to supervise these real estate agents under the statute. They have a sort of a duty to keep an eye on them and monitor what they're doing. And the real estate brokers are required to maintain insurance, for example. And that insurance covers, the brokerage firm as a whole, as well as the agents who work for them. But this series of statutes also statutorily authorizes real estate brokers to engage real estate agents as independent contractors. That would be Mass General Law, Chapter 112, Section 87 RR, which roughly states that a real estate agent may be affiliated with a broker either as an employee or as an independent contractor. Now, there is no guidance on what factors or what facts would determine whether or not you are classified as an appropriate real estate agent employee or a real estate agent independent contractor. So you start to see what the central issue here was. You have this Massachusetts independent contractor statute that sets out these three prongs, this three-prong test for determining whether or not a worker is an independent contractor or an employee. And then you have this real estate broker statute that governs their registration and licensing that says, these brokers have to have a certain degree of supervision over the real estate agents, and they can be engaged as either employees or independent contractors per the statute. And so the central issue in the case was this conflict between the independent contractor statute, especially prongs 1 and to some extent prong 2, which we discussed last week, and this real estate licensing series of regulations. Now, the independent contractor statute supported the real estate agent's claims that they are employees, while the real estate broker statute, or the real estate licensing and registration statute, supported the real estate broker's defense that their agents are or can be classified as independent contractors. Now, this case made its way all the way up to the highest court in Massachusetts, which is called the Supreme Judicial Court of Massachusetts, or otherwise the SJC. And it was a pretty big case for real estate brokers in Massachusetts, and there were amicus briefs filed in the case because the outcome of this particular case had a very broad impact on the real estate industry as a whole. Because you can imagine if all of a sudden the SJC finds that real estate agents are misclassified as in a general sense in violation of the Independent Contractor statute, then you're going to have thousands of Massachusetts real estate brokers owe potentially millions of dollars in back wages, potential workers' comp coverage, a whole host of things, overtime. All of these potential damages were at stake here, as well as the future cost of running a real estate brokerage firm. If all of these real estate agents are now, if the court had ruled that all these real estate agents have to be classified as employees if they fail to satisfy all three prongs of the Independent Contractor statute, then that would dramatically increase the cost of doing business for real estate brokers generally. And so this was a big case for that reason, and not only those, but then you have the possibility that those damages could be tripled, that the agents could have been awarded attorney's fees and costs. The penalties were potentially huge, and it would have resulted in sort of cascading litigation by real estate agents across the state. But in 2015, the SJC heard oral arguments on this case and issued an opinion. And the court ruled essentially that the real estate brokerages can continue to classify their workers as independent contractors. But the opinion was not, it was kind of lacking in a number of areas that we're going to get into. But the case itself was unique and sort of distinct from your general assessment or evaluation of the whether an employee is whether a worker is an employee or an independent contractor, because there was this series of statutes that specifically authorized real estate brokers to classify employees or to classify agents as independent contractors. And usually that's not the case, but in the examples that I'm giving you today, just about every single one of these examples has a special circumstance like that. And the reason why I wanted to bring these cases up today is because I do get calls. We get calls in our office where people have maybe, they've heard a little snippet about one of these cases, or they have a friend who's, a real estate agent and they're classified as an independent contractor and there's nothing they can do about it. Or, they have a taxi cab driver friend who's paid as an independent contractor, and, they sort of analogize that business model to their business model. And, they'll say to us, well, look, they can, they're classified as an independent contractor. Why can't I classify the workers in my business as independent contractors? They're similar sort of business models. But in these particular cases, the exception sort of proves the rule. And the exceptions here all have some sort of statutory or regulatory component to them that authorized the classification of the worker as an independent contractor. Now, what the court did in Monell versus Boston Pads, what the court did was that it examined the Massachusetts Independent Contractor Statute and the legislative history, as well as the real estate broker series of statutes and the legislative history behind those, and essentially said or reasoned that in part because the real estate broker, the real estate licensing series of statutes were enacted after the Massachusetts Independent Contractor Statute, they had more recent authority. And when you combined that with the fact that the Massachusetts Independent Contractor Statute is a really general statute, it applies very broadly to virtually all work in the state, whereas the real estate broker statute is a very specific statute that was targeted to a very specific industry. And so the court reasoned that the legislative intent there, where the real estate broker statute was more recent and was specifically targeted at a particular industry and a particular job type, that the real estate licensing statute controlled, in a sense. But what was interesting is that the court really didn't stop there, but they also didn't decide anything further. I mean, what was sort of telling about the court's decision in this Monell case was what they didn't say. And in a nutshell, what they didn't say or what they didn't do was make a determination as to whether the real estate agents in that particular case should have been classified as employees or independent contractors. And the court noted in its decision that those issues, that particular topic wasn't briefed. It wasn't really part of the plaintiff's claim or case on appeal. And because of that, the court decided not to go and answer that particular question. All the court did was essentially said that the independent contractor statute did not supersede the real estate licensing statutes. And in its decision, the court recognized that a wage claim or a claim for misclassification as an independent contractor could still be successful against a real estate brokerage if the broker really was found to treat its agents like employees, regardless of whether or not the real estate brokerage classified its workers or its agents as independent contractors on paper. So ultimately, real estate brokers out there should be very wary of this particular decision and how it impacts their business model, because although the court did not find that in this particular case these agents were misclassified, they left open the possibility in the future that if a particular broker-agent relationship were significant enough, they could find then that they were misclassified as independent contractors and should have been classified as employees. Now, what types of factors would go into that? I mean, I think some of those factors were in play in the Monell case, where you had these set hours and people were showing up at particular times to a particular office and answering calls, taking out the trash. Those are all certain factors that would lead you to believe that a broker employer was exercising control and direction over these agents. But because of the way, because of the language of the real estate licensing statute and the fact that a broker has a statutory requirement to exercise some sort of supervision / direction and control over the agents, I think in this particular case of real estate agents, a broker would really have to go above and beyond and exercise a significant amount of direction and control over the employees, every minute of the day, what they're doing, training, maybe controlling all of their marketing and their vehicle, website. I mean, the facts, the specific facts of that case would need to be looked at to determine, and I think the court would do so, would look at those facts to determine whether a real estate broker had misclassified an agent. So that's still out in the air, that's still undetermined. And, if you're a real estate broker out there and you've got agents, it can't hurt to reach out to your attorney and ask your attorney to take a look at this case and maybe some other history, the statute itself, and to determine, based on other case law that maybe can be analogized to the real estate, to this Monell case, and determine whether what the broker is doing with its agents could result in a finding of misclassification. So the next case involves cab drivers. Now, there's probably thousands and thousands of cab drivers out there, and I know for certain that there are quite a number of cab companies out there. It seems like for every 2 or 3 medallions out there, you have a cab company that owns them. And then you have your dispatch companies, you've got your cab garage companies, all sort of exercising one degree of control or another over cab drivers. And this particular case was called Sebago versus Boston Cab Dispatch, although there were additional cab companies involved. Essentially, these cab drivers had sued a handful of cab companies and the radio dispatchers garage, essentially claiming that they were misclassified as independent contractors. And as a result, that they were deprived of minimum wage, of overtime pay, of tips, and all the other protections afforded by the Massachusetts Wage Act. Now, this case, just as in the real estate agent's case, this case involved a municipal regulation. The real estate agent case involved a state statute, but this particular case involved a municipal regulation that was specifically applicable to taxicab licensing. And it expressly permits taxicab drivers to be classified as independent contractors. So in this case, the court had to determine whether licensed taxicab drivers in the city of Boston may be classified properly as independent contractors in accordance with the Boston Police Department Rule 403 of the Hackney Carriage Rules and Flat Rate Handbook of 2008. Now, I know that's a mouthful, but essentially this is a municipal regulation put out by the city of Boston that regulates the taxi cab licensing. That's basically the gist of it. And Rule 403 provided the basis for classifying the taxi cab drivers as independent contractors. Just as in the real estate case, the statute, the real estate licensing statute provided the basis for classifying agents as independent contractors. And Rule 403 of this Hackney regulation, regulatory scheme, sets forth a comprehensive set of regulations for the Boston taxicab industry. It was created by the city's police commissioner pursuant to his authority granted by the state legislature. And this particular case also made its way to the state's highest court, which held that although the Massachusetts Independent Contractor Statute applied to the taxicab industry, drivers did not provide services to cab companies or taxicab garages, and they were free from control and direction from cab companies. Now, that should sort of ring in your ear, prong one from last week, when you're examining whether the worker or whether the employer has substantial direction and control over the worker, then you're going to have a hard time satisfying prong one of the independent contractor statute. And that was at play in this case. So essentially, the court was saying that the taxicab companies, the dispatchers, the garages, they were not exercising sufficient control and direction over these taxicab drivers to fail to satisfy prong one. And the court also found that the services provided by the taxicab drivers were not in the ordinary course of business of the cab companies. Now, I don't know if I personally totally agree with that. I think that maybe it's a little bit of gray area that could have gone either way. But in this particular case, it seemed as if the court essentially reasoned that the cab companies weren't necessarily in the business of driving people around from point A to point B. In a sort of basic sense, these cab companies, all they do is hold a medallion. They just own a medallion, and that's essentially it. The radio dispatch companies, all they really do is take calls and dispatch information. And then the cab garages, all they really do is fix cars and maintain them. none of those things are things or services that the taxi cab driver is providing. So the court found that that prong 2, that these drivers did not, or that these taxi cab drivers satisfied prong 2. They could still be, assuming that they passed prong 3, they could still be classified as independent contractors. And so the court then looked at and found that the drivers were customarily engaged in an independently established trade, occupation, profession, or business. And this is prong 3. And, prong 3, the determination of prong 3 here had a lot to do with the specific language of Rule 403. And all the regulatory requirements and restrictions on the taxi cab driver's conduct that Rule 403 imposed, and not necessarily what the taxi cab companies imposed on the drivers. So in that particular case, in the Sebago case, the court ultimately found that these taxi cab drivers were properly classified as independent contractors. And once again, you had a regulatory scheme, this Rule 403, that gave the taxi cab companies and the dispatch company and the garages sort of cover to classify the driver as an independent contractor. Just as in the real estate agent case, you had the cover of the real estate licensing statutory scheme. So we're going to take a real quick break right there. You're listening to the Business Blog with Travis Jacobs of the Jacobs Law, and we will be right back in a few minutes.
Have you wondered about what it would be like to host your own radio show? Perhaps it's to help your business or organization, or maybe it's to help the community. Perhaps it's a hobby you'd like to pursue. Whatever the reason, I can help you. I'm Francesca Luca, longtime radio host of the radio show Talk with Francesca, and I have coached many radio hosts to make their dream a reality, and I want to help you too. Stop wondering and find out today how to turn your idea into a radio program. Visit talkwithfrancesca.com and fill out the contact form, or call me at 978-880-5740. I look forward to talking with you about your ideas.
Okay, welcome back to the Business Blog with your host, Travis Jacobs, the managing partner of the Jacobs Law. We're talking today about some cases that are relevant to last week's show involving the classification of workers as either an independent contractor or an employee. We just went through 2 cases involving real estate broker industry or real estate agent position and the taxi cab industry. And the last case I want to just quickly go over is a case involving truck drivers. It's also a somewhat unique case, which involves delivery truck drivers of trucks with a gross vehicle weight rating of, I believe it's 10,000 pounds or more. Now, there have been a few cases involving this particular issue of whether truck drivers of this size of vehicle can be classified as independent contractors, or whether their classification and compensation are regulated by the state law. And one case in particular is called Chambers versus RDI. And this case went up to the Supreme Judicial Court, and they rendered a decision in December of 2016. Now, what's interesting about this case and this sort of line of cases involving these truck drivers is that not too long ago, someone came up with the idea or the defense for these transportation or logistics companies that the Federal Aviation Administration Authorization Act preempts the Massachusetts Independent Contractor Statute. Now, that's quite a mouthful for an act. It's called the Federal Aviation Administration Authorization Act. For short, we call it the F-Quad A. And this particular act applies to, or in this particular act, it provides that truck drivers over a certain amount, who drive a truck over a certain weight, may be exempt from overtime. And also provides that they can be classified as independent contractors. So in Chambers, the court had to decide specifically whether the F Quad A preempted the Massachusetts Independent Contractor statute. So that essentially, if you had a truck driver, or if you engaged or employed a truck driver who was driving a truck over the minimum weight limit, you could properly classify that driver as an independent contractor, regardless of what the Massachusetts Independent Contractor statute said. And so obviously, plaintiffs' attorneys who represent the truck drivers said the exact opposite. Their claim or their argument was that the F Quad A does not preempt the Massachusetts Independent Contractor statute. But ultimately, there was a federal case and there was also a state case in Massachusetts, and ultimately the SJC found in this Chambers case that only prong 2 of the Massachusetts Independent Contractor statute was preempted. And essentially, prong 2 is whether or not the worker provides services which are in the usual or ordinary course of the employer's business. Now, obviously, if you run a logistics company where you're delivering goods from point A to point B, and you have a worker who drives the truck to deliver the goods from point A to point B, that is going to be in the usual course of the logistics company's business. So under the independent contractor statute, if you classify that worker as an independent contractor, they won't satisfy prong 2. They will not meet that standard, and so they would be classified as an employee under state law. But now, since the SJC in Chambers ruled that the F Quad A preempts prong 2, these truck drivers would have to prove that they don't meet the test for prong 1 and prong 3. So in other words, these truck drivers, or if you employ or you engage independent contractors as truck drivers, you would have to show that you do not exercise enough control or direction over these employees such that you satisfy prong 1 of the 3-prong test. Now, the court will look at a variety of factors. Do you require that your drivers wear uniforms? Do they wear a shirt with your logo on it? Do they, that's a certain color? Do they have to wear a certain color pants? Do they have a hat with your logo on it? Do they show up at a warehouse at a particular time of day? Are they required to drive a particular truck? Does the logistics company own that truck or lease it from another party in the logistics company's name? Does the driver, do they have their own phone number, their own website, their own company? Do they own multiple trucks or lease multiple trucks in their own name? Does the driver have his own insurance? Does the logistics company buy their insurance, their general liability insurance, their workers' comp insurance? Does the logistics company provide the route that the driver drives to deliver all the goods every day? Who loads the truck? Does the driver load the truck, or do other employees of the logistics company load the truck? All of those facts are going to go in, are going to be looked at by the court to determine whether or not the worker meets prong 1. And after Chambers, that's what you have to do in these type of truck driver cases. You have to go and attack it from prong 1 and prong 3. And so prong 3 is whether the services, or whether the worker is customarily engaged in an independently established trade, occupation, profession, or business. You look at it and you ask yourself, is the truck driver simply wearing the hat of the employer, or is he wearing the hat of a truly independent business? And this is a very fact-intensive analysis. And in some cases, you may have the truck driver literally wearing the hat of the logistics company. They may be wearing the hat of the logistics company with their logo on it. And And that's not going to, fare well for the logistics company who's trying to show that the truck driver is truly an independent contractor. But in essence, if the F Quad A allows these truck drivers to be classified as independent contractors, anytime you engage a truck driver as an independent contractor, you need to examine the services that worker provides, that truck driver provides, through the lens of prong 1 and prong 2, prong 1 and prong 3 of the independent contractor statute. And in the Chambers case, essentially, the court found that the trucking company may still be misclassifying its drivers as independent contractors if the plaintiffs, the truck drivers in that case, were able to show that the logistics company was treating its drivers like employees by exercising direction and control, and by having the worker, the truck driver, essentially wear the hat of the employer. So those are the three cases that I wanted to go through on the issue of misclassifying or classification of workers. It's a big issue in Massachusetts, and I cannot tell my listeners enough that they really need to pay attention about to the type of workers that they engage. And if you are engaging independent contractors to provide services for your company, you really need to talk to an attorney who understands these statutes, that has experience in this area, who keeps up with the case law, to go through the very specific facts and circumstances of your relationship between your business and the worker, to determine if you're properly classifying them as an independent contractor. Because as I explained last week, and I think I might have said earlier today, the penalties are huge. If you fail to properly classify a worker, you have essentially, more often than not paid the proper wages. You haven't paid overtime, you've done no withholding, you have not paid workers' comp insurance, unemployment insurance, you haven't paid the employment taxes, and it can get super expensive. And the base damages can be huge. And then you're stuck, with the possibility of triple damages, attorney's fees and costs, and personal liability. And on top of all that, and I don't think I mentioned this last week, but on top of all of that, it's a crime. It is criminalized in Massachusetts for failure to properly compensate your workers. So it's really something that people should pay close attention to, and I urge you to reach out to an attorney, to discuss those classification issues. Okay, so last week at the end of the show, I kind of got into paying employees, paying your workers, compensating employees, and some of the various issues that come up in that. I'm going to dive into that now. I was hoping to get through it a little bit more than it looks like I'm going to get through today, but I will promise that I will pick up on that next week, and you'll be able to hear the end of this show and next week's show either live on Saturday from 12 to 1 or on the podcast that you can get by downloading the WBIX 1260 phone app. So with every show, I try to give the listeners a really plain language understanding of what is required of a business in Massachusetts. And a huge thing, like I've said, is classification of workers. Another big thing that gets a lot of businesses in trouble, and a lot of small mom and pop, 1 and 2 owner businesses in trouble, is compensating their employees. Without fail, we get calls about this all the time, and we get them from both sides. We have, employees who have not been paid properly, calling us on the phone and explaining it to us, and then we also have employers who have been sued, who call us up and essentially explain they had no idea that XYZ was a requirement. And it's tough. It's tough for these businesses and these business owners, because there's generally no intent there. There's generally no intent to break the law. It's just that the laws are so complex, and there are very few places that employers can go to find a very concise list of all the compliance regulatory requirements that they have to satisfy. And so inevitably, small business owners who don't have a lot of resources for in-house attorneys and professional human resource directors or managers, they run into trouble. And that's kind of where that's kind of a niche that our firm has found that we fit in nicely with. So compensating employees, the relevant state laws here tend to be the Massachusetts Minimum Fair Wage Law, the Massachusetts Wage Payment Law, and the Massachusetts Equal Pay Act. There's also the Federal Labor Standards Act. If you Google any one of those statutes, you'll find a ton of information on them. Of course, it tends not to be all in one place, and some of it's not completely accurate. So I still urge you to contact an attorney, but at least if you Google them and look them up, you'll be able to get a general sense of what the requirements are. And you'll be that much more informed when you talk to an attorney. So, as with misclassification, and as I stated a few minutes ago, there are steep penalties for the failure to compensate your employee properly. For that reason alone, this is something that you should pay attention to. I talked a little bit about what minimum wage was, and explained what overtime is, and essentially, last week I explained, overtime is the time that a worker works over 40 hours a week. And so if you have a worker who works 45 hours and they're paid an hourly wage, you need to compensate them at time and a half, or 1.5 times their regular wage for those 5 extra hours they worked each week. And unfortunately, a lot of business owners don't understand that. But there are exemptions. And so that's what I wanted to get into today in a lot of detail. I have cases that I wanted to go through to give my listeners some specific facts that they may be able to relate to their business to get a better understanding of who's exempt and who's not. So certain employees are exempt from overtime. There are state and federal definitions of these exemptions, and that provide the criteria for what constitutes an exempt employee. Now, Massachusetts tends to adhere to the federal definition of exempt employee found in the Fair Labor Standards Act, but it also has some additional state-specific tweaks, and we're going to go through some of those today. So to start, the certain categories of employees that are exempt from mandatory overtime requirements are bona fide executives or bona fide administrative or professional employees, including some computer employees. And these are defined in the Federal Fair Labor Standards Act. So you can Google bona fide executive exemption or bona fide administrative exemption, and you'll find some basic information online about what factors are used to determine whether or not a worker or an employee meets this exemption from overtime. But you can imagine just from the title, what kinds of things you need to look at. So if you have a bona fide executive, everybody kind of has a general understanding of what an executive is. They're a higher level employee who has management control, they're supervisory control, and the Fair Labor Standards Act sets forth some of the criteria for determining that, and I'm going to go through that. The primary test, though, the first sort of hurdle that you have to pass when trying to determine whether your employee meets one of these exemptions is are the primary duty test and the salary basis test. To qualify for any of these exemptions, the executive, administrative, professional, or computer employee exemption, the employee must be paid on a salary basis no less than $455 per week. And your job duties, whatever job title you give the worker, has really no basis in determining whether they're exempt or not from overtime. So even if you call someone, their job title is executive director of dog walking, doesn't necessarily mean that just because they are titled as an executive that they're going to be exempt from overtime. That seems kind of obvious, but a lot of people may not realize that. It really matters, in fact, what they're doing on a day-to-day basis. What are their duties and responsibilities? But primarily, the salary test, the salary basis test, is going to be your first hurdle to overcome. So if you're not paying this worker $455 or more per week, then you're not going to qualify. They're not going to qualify as an exempt employee from overtime. Now, you may find some things online where that say that number is $945 or something along those lines, because the prior administration, under the Obama administration, had put forth a change to this rule, and they had increased the minimum salary for the salary basis test to something like $945. But what happened was someone sued over the potential enactment of this executive order, and that change is essentially stalled in the courts. I believe the case is down in Texas, and a stay on enforcement of that executive order was put in place, and so there was no change. Although you will find tons of information online that claims to suggest that this is the new rule, because everybody expected that was what was going to happen, but it didn't. And so, at least for the time being, at least today, June 21st, as I record this show, it is $455 per week. That is the minimum for the salary basis test to meet any of these exemptions for executive, administrative, or professional, or computer employee. All right, so let's start really quickly with the executive exemption. I think we'll be able to get through this one today, and I'll probably have to pick up with the other exemptions next week. But to qualify for the executive employee exemption, all of the following tests must be met. Obviously, the salary basis test, you have to be paid $455 or more a week. Then you have to, your primary duty, the worker's or the employee's primary duty, must be managing the business or managing a customarily recognized department or subdivision of the business. So you may have something like a department of sales, or a department of inventory, or a department of customer service, or an HR department. If your employee is managing that department, their primary duty is managing that department, then you will pass, or you will meet this primary duty test. Now, there's case law that says that the percentage of time that an employee must be engaging in those primary duties is 50% or more. So, for example, you cannot give a worker, a small piece of the management, and so maybe they spend 5 or 6 hours of a 40-hour work week, or 10 hours of a 50-hour work week, dealing with management issues. It's not going to cut it. If the other 40 hours a week they're doing sort of manual labor or very simple menial tasks, they are not going to qualify for the executive exemption, because they'll fail to satisfy the requirements of the primary duty test. And the third part of the test is they must customarily and regularly direct the work of at least 2 or more other full-time employees or their equivalent. So oftentimes, and I've seen this before, you'll have a bona fide executive who's engaged in essentially their primary duty is management of the business. They're doing it 90% of the time, but they are only overseeing one person. And if that's the case, they're not going to satisfy that part of the executive exemption. And so they will be entitled to overtime. And that, that in very small businesses, that is a difficult situation because you very often don't have that many employees to begin with. And so you may, even if you have a department, even if you're a business that's big enough to have separate departments, you may have this so-called executive being paid maybe $450 a week, but they only oversee, they may be paid $455 or more a week, but they only oversee one employee, even if their primary duty is management, and they will not be exempt from overtime. And then the last part of the test is they must have, the employee must have the authority to hire or fire other employees, or the employee's suggestions and recommendations as to the hiring, firing, advancement, promotion, or other change of status of other employees must be given particular weight. So what does that mean in really basic layman's terms? It means this particular employee that you're seeking to be exempt from overtime, they have to have some power. They have to have real power to hire and fire workers, or you have to at least base the hiring and firing decisions that you make at your business on what their opinion is. So you could have an employee who makes recommendations to you, or they evaluate other employees, and their performance, and then those performance evaluations are used to make a hiring and firing determination. That may satisfy, if all the other elements of the test are satisfied, then you may have, that worker may be exempt from overtime pursuant to the executive exemption. So real quickly, I'll get to the administrative employee. So administrative employees, to qualify for this exemption, each employee must satisfy the following. First, the salary or the fee basis of $455 per week. They have to have a primary duty where their primary duty must be in the performance of office or non-manual work directly related to the management or general business operations of the employer or the employer's customers, and includes the exercise of discretion and independent judgment on significant matters. All right, so again, this is going to be 50% of the administrative employee's time must be spent on the performance of office-related work, administrative tasks, non-manual tasks. They can't be out there digging ditches, and you're calling that an administrative employee. They have to be doing things, like filing, copying, maybe spreadsheets, keeping track of books and numbers. They need to be, managing, not managing employees, but they need to be interacting with employees, and using their own judgment in the performance of their services. They can't be simply reading from a script, or just following a flow chart. If A, then go to B. If C, then go to D. That person's not going to be deemed exempt from overtime under the administrative exception to the overtime rule. So I think we're going to end it there for the day. I will tell you that next week I'm going to pick up right where I left off on this administrative exemption to the overtime rule, so I hope you tune in. You can listen to all of our podcasts on, if you download the free app from, or the WBIX 1260 free app, you can get that on the Google Play Store or the Apple Store. You can also go to the website, www.thebusinessblog, which we'll have up maybe in a week or two. You'll be able to download all of our shows there, and you can also download it and download the phone app from AM1260thebuzz.com. I want to thank everybody for joining me on this Saturday from 12 to 1 p.m. I will see you next Saturday at 12 o'clock. And have a great day. This is your host, Travis Jacobs of the Business Blog. I wish you all a very great weekend.
Welcome to the Business Blog with lawyers from Boston law firm the Jacobs Law. The opinions and information discussed during this show are of a general informational purpose only and are not intended to be specific legal advice and should not be used to make specific legal decisions. You should always consult an attorney who knows and can advise you based on the facts and circumstances specific to you and your business. Prior cases and case law discussed are not an indicator of future results or outcomes. Your host for today's show, Attorney Travis Jacobs, is a licensed attorney in Massachusetts and is the managing partner of the Jacobs Law. He has been working to help entrepreneurs and small businesses for almost a decade, and for the last 4 years has been selected by Super Lawyers magazine as a rising star in business litigation. And now, here's Travis Jacobs.
Okay, ladies and gentlemen, welcome back to the Business Blog with Boston law firm the Jacobs Law. I am Travis Jacobs, the managing partner of the Jacobs Law and host of today's show, The Business Blog. For all those business owners and entrepreneurs out there who don't already know, I want to tell you a little bit about the Jacobs Law. We are a business law firm. So what does that mean? It means that not only do we run our own business, but we represent business clients and entrepreneurs, and we help people who are looking to start a business or buy a business. We help people looking to sell a business. We almost exclusively represent small and mid-sized businesses and entrepreneurs at the Jacobs Law. And we also help people with contract disputes, drafting contracts like employment contracts, independent contractor agreements, non-compete agreements, partnership agreements, all sorts of contracts. We help people file trademarks, deal with ownership disputes, obtain licenses and permits like an alcohol liquor license, or even a municipal license like a used car dealership license. We handle all of these things, and a big part of our practice involves representing businesses that are involved in litigation. We represent businesses from both sides as plaintiff and defendant for things like breach of contract, ownership disputes, partnership disputes. And we do licensing and permits at the municipal level and the state level. So, for example, if you've received an order to show cause from the Division of Professional Licensure, that's something that the attorneys in our firm can assist you with. So before I start today's show, I want to get to a quick disclaimer. The hiring of a lawyer is an important decision that should not be based solely upon advertisements. This radio show is not intended to be an advertisement or a solicitation. The statements made in this radio show are of a general, informational nature only, and are not a substitute for individualized legal advice. You should always contact an attorney directly to discuss the facts and circumstances of your particular case and specific to your particular business or legal issue. No action should be taken in reliance on the statements or opinions made during this show, because every case is different. The description of court cases, decisions, awards that we go through in this radio show do not guarantee a similar outcome in current or future cases or in your particular case. Transmission of the information in this show is not intended to create, and its receipt does not constitute, an attorney-client relationship between the Jacobs Law, Travis Jacobs, and any listener. Okay, we got the disclaimer out of the way. Now let's get to today's show. I want to do a quick recap of last week's show because it pertains a lot to some of the issues we're going to talk about today. If you didn't catch last week's show, you can listen to it anytime by downloading the WBIX 1260 phone app from the Apple Store or the Google Play Store. And you can also find it on am1260thebuzz.com. It is a free app, and you can listen to all the Business Blog shows anytime you want. We're also getting a website together for the show, and the URL for that will be www.busines thebusinessblog.com, and that's business and then bLAWg.com. So if you're listening to the show when it airs on a Saturday from 12 to 1 p.m., or at least this Saturday from 12 to 1 p.m., the URL, the website won't be up yet. But if you're listening to this recording on the podcast in a week or two, then you'll be able to go to our website, download our show, and get some additional resources and information. So last week we discussed the classification of workers as either employees or independent contractors. Now this turned out to be a pretty hot topic for our listeners, so I just want to dive back into it a little bit and go through a couple of cases that I found interesting that sort of exemplify where the end of these rules, sort of where the rubber meets the road. We explained last week that Massachusetts has one of the strictest tests in the country for determining whether a worker is classified as an employee or an independent contractor. Under Massachusetts law, there is a presumption that all workers are employees for the purpose of paying wages and salaries. And the worker must meet every single element of a three-pronged test to be properly classified as an independent contractor. And that's one of the reasons why it's one of the strictest tests in the country, because the worker and the services they provide, their relationship to the employer or the party that pays them, has to meet every single element of all three of these three prongs. And the failure to meet any element or any one of the prongs results in the employee being classified, as far as the law is concerned, as an employee. So if you have a worker who you're classifying and compensating as an independent contractor, and you listen to last week's show and you realize that you may be misclassifying them, it's certainly something you should take a look at. You should call an attorney to discuss your specific circumstances to determine if you need to take corrective action, and also determine if you need to start compensating that worker as an employee going forward. Of course, there are exceptions to every rule, and we got into those a little bit in last week's show. But there are a couple of additional examples based on some cases that I wanted to just talk about quickly today. It might take me about 20 minutes, but I think they're really informative as far as these particular industries go. And so if you're an employer out there in the industry of a real estate broker or a trucking, transportation delivery company or a taxi cab company, these cases are really relevant to what you're doing. And they're also very unique, and they sort of represent the exception to the rule, which is why I wanted to bring them up. So first is the real estate agents. There was a recent case. The title of the case was Monell versus Boston Pads, LLC. Now, in this particular case, Monell, the plaintiff, and 3 other real estate agents filed a civil action against several real estate broker firms, alleging that the real estate brokers had violated the Massachusetts Independent Contractor statute by misclassifying them as independent contractors rather than employees. The real estate agents claimed that they had been treated as if they were employees by the real estate brokerage firm, but they were paid as independent contractors. And obviously, they received a 1099 every year instead of a W-2. They did not have withholding taxes taken out of their pay. They were essentially paid, either a flat amount or a commissions only on a commissions only basis.